I'm the only one, so I'll make this brief.
Glad to have you.
Thank you, Chairman. Senator. First of all, I'd like to express our appreciation to Senator Creighton for considering our concerns and comments on the bill that was filed. The committee substitute does reflect several substantial changes, which we're very appreciative of. In particular, the catch-all provision. Originally, the bill had two areas of focus, which were school finance and redistricting, but it also had a provision that could have been read much broader than that. That provision has now been eliminated, and we're very appreciative of that fact. There are some mechanical issues that we'd like to bring to the committee's attention, and those would be, first of all, original bill, there was a process by which the Attorney General would file a petition with the Supreme Court. The Supreme Court could request petitions. There would be a deliberative process, and a decision would be made as to whether or not the substance of the bill, the substance of that petition met the conditions of the law. That process has been removed, and what we have now is simply a shall. Upon the Attorney General's petition, the Supreme Court justice shall create the court, this three-judge panel. In addition to that, there does remain in the bill a transfer of related actions. There's not good definition of related actions. It does say from the same nucleus of operative facts. And with the tightening of the two areas, we do think that solves a good bit of the problem. But it's not clear in the bill how that decision would be appealed, who would decide that decision, what rights of interlocutory appeal might exist if a case that was ongoing was transferred into the creation of a three-judge panel. Original bill did not specifically address the concept of a jury trial. It does appear that in these two areas of school finance and redistricting, these are often issues that are questions of law that are appropriate, and we have good procedures for how a three-judge panel might operate in that environment. But to the extent that a jury trial was involved, there's not mechanics of how this three-judge panel would necessarily operate in a jury trial. Finally, the bill does appear to remain retroactive. The effective date appears to be immediate, and thus it would apply to pending claims. Again, our primary concern was the catch-all provision because we thought there was opportunities for mischief there. We're very appreciative for the authors who have taken that provision out. We think that does a great deal to streamline its application and the potential for any misuse. Our testimony here today is simply on mechanics that we've presented to the author and which we'd be happy to help in any additional and further way to help clarify within the bill. Happy to take any questions.
Thank you. Any questions? If not, thank you.